Good morning and welcome to the Lex Communiqué, the official legal podcast of the Thakur Ramnarayan College of Law. I am Namrata Gupta and I'll be your host for today's episode. Lex Communiqué is a platform where law students meet lived experiences. We engage with legal minds to explore doctrine, practice, and the evolving realities of the justice system. Today, we are privileged to be joined by Justice Rebello, whose judicial career and contribution to the development of law have left a lasting impact on the legal education and the practice. In this episode, we'll be discussing arbitration, its role in modern dispute resolution, the balance between judicial oversight and party autonomy, and how both international and Indian arbitration frameworks are evolving in the legal recourse. Justice Rebello, it is an honor for us to have you with us today. Thank you for joining at the Lex Communiqué 2026.
Thank you so much.
Yes. We have certain questions that we'd like to proceed with. One of the questions is that arbitration is often described as the backbone of international commercial dispute. In your view, what makes arbitration particularly effective for the cross-border disputes?
See, if you look at it in the context that if every person had to file a suit where the cause of action arose, just imagine the consequences of first selecting the forums, then getting it enforced to some other forum, in some other jurisdiction, in some other country. So therefore, it is in that context that from the very beginning, international trade evolved the system of arbitration. So it has not come up just like that. It has a long history that merchants, traders came across and developed international arbitration. This was a means of dispute resolution, so that they could go and select one jurisdiction in respect of which all their disputes across countries could be settled. And therefore, we have seen various institutions today across Europe, Asia, and other parts of the world where parties decide to which forum they will go. Now, there would be, say, a country X has got a plant in India, but they may not be very happy to have arbitration in India. So they will select a clause to say that we will go to X country, X forum, and that forum will decide the dispute. Then they will decide the dispute in the context of what is the law of arbitration, what is the substantive law of arbitration, which is very important. So all these aspects have gone into, and therefore this has become a very effective means of settling cross-border disputes.
Yes, sir. So following up to that question, you said that we now prefer institutions. We have it in India as well. So when a matter has been, the dispute has arose, so how does one decide which institution to select or which institution to go? So is India the preferred institution, seat or the venue for the parties across the globe?
Now, when you speak about institutions, in India, basically so far it has been ad hoc arbitrations, not institutional arbitrations. Okay, there are few institutions which have now emerged in the last 10-15 years. For example, Bombay, you have the MCI.
MCI, yes.
Okay, IMC to some extent also are institutions. And there are some in Delhi, in Madras. So wherever there have been arbitration places where the arbitrations are there, institutions are emerging. But yet, majority is still ad hoc arbitration. Now, institutional arbitrations in India have a long way to go.
Yes.
Okay, and basically what we are dealing with is only domestic arbitration most of the time.
Yes.
Some international arbitration, most of the time matters are domestic arbitrations. But you must remember one thing, that any arbitration in India, if there's a foreign party, that becomes, for the purpose of the Act, international arbitration. But the principles are the principles of domestic arbitration.
Yes, sir.
So it becomes a domestic award. It does not become an international award. It becomes a domestic award insofar as India is concerned.
Yes, sir. So the next question is, what are the principal grounds in which enforcement of a foreign award can be refused in India?
See, we have adopted the New York Convention. Uh, Basically, those are the areas of, for example, public policy. Way back, this has been accepted that public
Yes.
policy, and public policy is looked into various concepts. We apply some tests in domestic arbitration, which is now Section 34, Public Policy of India, and there is what is called international public policy. When we apply to that, a step higher than the principle applicable to uh, domestic arbitration in India. Now, you see, what happens is there are various words which have been used in public policy. Now, if you look at Section 23 of the Indian Contract Act, now most of those words are there. Public policy is there, plus other expressions are there. But basically, the New York Convention, Renu Sagar was the first matter, where the principles of New York Convention and public policy came into Indian jurisprudence. Renu Sagar was the judgment of the Bombay High Court,
Okay.
which thereafter went up to the Supreme Court, and the principles of public policy have been accepted in that judgment.
So, moving forward to the next question, with the growing emphasis on the institutional and emergency arbitration, do you see India as the emerging preferred global arbitration hub? Because we do have countries like UK and Singapore, which have aligned with the arbitration. They are very pro arbitration countries. So, how does India look in the coming years?
What I see is people have conventions and speak about India being being a base for arbitrations. We have the political class speaking about it, but honestly, will you ask me? I'll be honest in that.
Yes, sir.
Interference even in domestic awards in India is very, very high compared to other countries.
Yes, sir.
Now, the very structure of the Arbitration Act is hands off, because you are selecting arbitrators of your choice, of your choosing,
Yes.
knowing that they have expertise in that field. So, therefore, you can't treat an arbitration like an ordinary appeal, which many courts were doing until recently. Now there seems to be a change. Don't interfere with arbitral awards unless there is something manifested, arbitrariness in it, public policy or the ground which are available under 34.
Yes, sir.
So that is really so far as domestic awards are concerned. Foreign and whether I have done arbitrations in Singapore, I have done arbitrations in UK, LCIA, ICC, SIAC.
Yes.
Interference by the court is minimal. There's hardly any interference with the final arbitral award. And there's a timeline. Okay? A timeline is given, nobody is allowed to break the timeline.
Okay.
Now, in so far as we are concerned, especially ad hoc arbitration, we grant time for the asking. At the same time, some arbitrators have so many arbitrations that they can't give reasonable time. And it goes across. It is not. See, when I go to a foreign arbitration, in the matter of 3 to 5 days, evidence is recorded, arguments are heard, and matter is over within 5 days.
Okay.
Everything is over. Now, here we start the process on day 1 and continue it for one does not do so many extensions.
Yes.
So this practice must go off for anybody to have faith in your system. Okay, now MCI, for example, has everybody, of course, in the Act, Section 29 has come in, where limits are given. But even most of the time, those limits are not largely because of the lawyers, to some extent by the arbitrators, but largely because of lawyers. Somebody will come and ask you, I have to go somewhere. Some excuse is always given. And if you don't grant adjournments, you are a bad arbitrator. So this has to go off.
Yes.
If somebody wants to people to come to India for arbitrations, you must tidy your system, not strengthen. Because the law is there. See, in Central was the law not prepared yesterday. It was prepared by experts all over the world. It was meant for international arbitration. We have also used it for domestic arbitration by twitching here and there. And we constantly go on changing the law, making amendments, sometimes without realizing what we are doing.
Yes, sir.
So the result is time lag. Interpretations by court is another issue, because sometimes interpretations are given based upon, we should follow Anglo-Saxon jurisprudence, basically. Now, sometimes we depart from Anglo-Saxon jurisprudence and go to continental jurisprudence, then some other jurisprudence. So then it is becoming a hodgepodge. The wording is a hodgepodge, a mismatch. You can't just bring in, if they are new concept, new dynamics, yes. But you are borrowing a dynamic, picking up from various jurisdictions to read an act. Now that is causing a lot of problems for arbitrators, for courts. So there has to be some sort of a uniformity in judgments. And judgments should not leave questions open for the next judgment.
Yes.
Many of the judgments, questions are left open. Now you can't have a system where questions are left open.
Yes, sir. So to end on that note, I have one last question to ask. That in recent times, there has been discussion that courts should be working on a Saturday as well. But in India, if we see that all the advocates who are actually litigants, like practicing in litigation, they're also practicing into the arbitration dispute resolution part. So normally they tend to choose the day, the timing and the dates in the public holidays, Saturday, Sunday, or in the later half, in the second half after 5:30. So how has the overall experience for you as an arbitrator been to discuss the timings or the dates and again the delay of the procedures happening?
I will answer it in 2 points, because you have raised a very important point which
Yes.
goes to the court.
Yes.
That court should work also on a Saturday. I don't know if you've ever gone to a high court or had a sitting with a judge of only one day. You know how many hours a judge puts in every day?
Yes, sir.
Can you tell me?
Sir, as per my experience, I've been through the courts and all. It's been over 12 hours because they also prepare for the next day.
So
And
every judge puts in 12 to 14 hours every day to sit on that bench to dispose of matters.
Yes, sir.
Now, if you tell me that I must work like government employee, fine. I'll work from Monday to Saturday, come to the court, sit down, read the file, dispose of 2 matters unfinished. Somebody calls you, go for a tea break. We'll be very happy. But that is not going to happen. That is not going to help the system. So when somebody talks about judges not working and judges must work, do you want to have them have a health checkup or mental breakdown? That can't happen. So second part now. As far as I personally as the arbitrator is concerned, I have my arbitrations from 10:30 or 11 o'clock to 4:30, 5 o'clock. All lawyers are available. Mine is not an arbitral center where people come for evening arbitrations. I don't accept that. Sometimes here and there, somebody says, okay, fine, give us a stretch in the evening itself. So fine, I said. Then 2 to 6 o'clock. So lawyers come. It's only when some people try to, they are also, I don't know why. If lawyers are arbitrators, of course, then this happens. Because they go to the courts, and then after courts they do the arbitration. But I can't understand how it is possible. See, to sit on the arbitral chair, you must read your file. So between your court work and arbitral work, where is the time to read the arbitral file? So some wrong practices are going on. But otherwise, regular arbitration, somebody starts at 10:30, somebody starts at 11 o'clock, 4:30, 5 or 6 hours arbitration, 1 hour lunch break is how systems are going on.
So, on that note, we'd like to thank you for the podcast, and we are really grateful to have you here with us.
Thank you so much.